What is a Spousal Lifetime Access Trust, or SLAT? A Spousal Lifetime Access Trust, also known as a SLAT, is an irrevocable trust where one spouse is the grantor and the other spouse is the bene. The grantor spouse will execute the trust, and the beneficiary spouse will have limited access to the assets in the trust. It's essential that the beneficiary spouse's access be limited to protect the assets from the creditors and estate taxes. The benefits of a SLAT is that it allows married couples to take advantage of the high gift tax exemption available to spouses, while also providing continued access to trust assets. Each spouse can establish a SLAT for the other's benefit, but the trust must be sufficiently different from one another. Under the reciprocal trust doctrine, if the trusts are too similar, the trust assets can be included in the estate and subject to estate taxes. In addition to providing income to spouses, SLATs can provide income to the grantor's descendants. Can a SLAT be contested or disputed? Yes, a SLAT can be contested or disputed if you have a basis to argue that the trust is invalid, just like any other trust. Some common grounds for contesting a trust include undue influence or duress. If the SLAT was created as a result of undue influence or duress by a third party on the creator, you can contest the validity of that trust. Undue influence occurs when the grantor does not create the trust of their own free will, but instead that free will is overwhelmed by the extreme influence of another person to create the trust, or to name a certain individual as a beneficiary, for example. Duress is a type of undue influence where the influencer uses threats of force, of violence, to bend the grantor to their will. Both undue influence and duress can serve to invalidate a trust. To successfully challenge a trust for undue influence or duress, the grantor must be under so much pressure that their free will is overwhelmed and the trust document represents what the influencer wanted instead of what the grantor would have wanted. Incapacity is another basis. For a SLAT to be legally enforceable, the grantor has to have sound mind when they create the trust. The legal standard for mental capacity is somewhat low, but it requires that the grantor essentially understand the implications of the actions that they're undertaking and the impact of those actions. SLATs are irrevocable trusts, but the standard for capacity is the same as it would be for other trusts and contracts generally. Fraud is yet another basis. In some situations, a bad actor might create a fraudulent SLAT that names them as a beneficiary and maybe even forges the purported grantor's signature. Fraud can also be used to gain the grantor's actual signature by misrepresenting what the document is that they're signing. This could involve telling the grantor that they're signing a different legal document or even a birthday card when they're actually signing a trust. Or it could include lying to a vulnerable grantor about the terms of the document, what the document is, or what it says. In any of these situations, the SLAT can be contested as fraudulent. Who can contest a SLAT? In order to contest a trust, including a SLAT, a person must have legal standing to do so. This means even if you want to challenge the terms of the trust, you may not be able to do so. To be able to contest a SLAT, in California at least, a party must have a property interest or a potential property interest that will be affected by the administration of the trust or the outcome of the litigation pertaining to that trust. Trust contests are usually filed by beneficiaries, heirs, or trustees. However, any individual who has a property interest in the trust property may also have legal standing to contest the SLAT. Do I need a trust attorney to contest a SLAT? Neither California nor Texas law mandates that you hire a trust attorney to contest a SLAT. However, trust contests can be immensely complicated, and having a knowledgeable probate litigation lawyer on your team can greatly improve the likelihood of getting the trust thrown out and invalidated. An experienced trust litigation attorney can evaluate the circumstances of your case to determine whether you have legal standing to contest the trust in the first place, as well as advise you on whether you have a legal basis to challenge the SLAT and what the likely outcome might be. At RMO, we protect people like you every day. Contact us today to see how we might be able to help.